Hello, welcome to the meeting of the Regulations Subcommittee of the California Paraprofessional Program Working Group. I'll take roll. Hartston?
Here.
Sarouche?
Here.
Thank you.
Okay, I don't think we have any attendees.
I'm looking.
No.
Oh, we do have some attendees.
All right.
If any member of the public wants to comment, please raise your hand in Zoom. I don't see any raised hands.
Okay. So Greg and I had a brief exchange just before the meeting to try to check in to see where we were and what we wanted to cover today. I know, Amos, we left some things uncovered in our last meeting because you wanted to talk about them with Fariba. I think the fees piece in particular. So we have not made it through then Greg's memo. Then of course we also have the sort of policy issues document that we were working on. So I'm thinking we would return to the Greg memo today. How does that sound?
That's fine.
Yeah, that sounds great. We might want to do a brief debrief from the full working group meeting where we had the resolutions and the open discussion, but I think, yeah, we should continue.
Okay. Why don't you go ahead and do that? I can stop sharing so we can just talk about that, the meeting.
So, and really, Greg, I'm most interested in your thoughts on what direction we got, if any, and if that changes sort of what you've already put together or what you think. But, you know, and I briefly debriefed Fariba already on what the resolutions were, and thank you for circulating those. So yeah, so I think for the two things we had voted on, we got clear direction, which was great, the MCLE and the financial responsibility, the bonds, and the malpractice. So I think, Greg, one of the things we talked about last time was placeholders for those and where they would fit in the rules. But I think you have the direction you need, right, to update those things. Probably the informed consent will need to be document or proposal will need to be updated a bit to better reflect those. I'm not sure what else. I mean, I'm interested in talking about the general discussion about fee caps and where that leaves us, or I shouldn't call it fee caps, regulation of fees, which could be fee caps, discipline, or other ideas. But as far as the resolutions, I think that was it, right?
I think that when we need to get to the fees because that's a controversial issue. And I watched the video from the meeting I missed, and there was a lot of good discussion, lots of substance. It's just that we never get to the fees. So I don't know what you want to do about that.
Well, we definitely wanted to wait for you to have that conversation because we knew that.
Thank you.
Yeah, well, I think just to have it, because I know both you and Amos maybe have different positions, maybe not. I don't know. On that particular issue. In terms of the feedback that we received, it's great we got a vote on the security bond. I still think that in terms of imposing the obligation to carry a security bond, I still envision that being part of the set of rules that stand up the program and the rules of court, potentially also a statutory provision to the extent that the legislature wants to impose that as well as a requirement of the program. And then disclosures about the security bond, I do think that we need to incorporate that in the informed consent rules under the rules of professional conduct. So failure to provide that disclosure. And again, I think it's helpful to make it in writing just because it's clear and it's a best practice. And we tend to, as I said before, in California, as compared to other jurisdictions, we tend to require informed consent in writing more than other states. So I think we talked a bit about, and I don't think we need to get into the weeds about what exactly that disclosure should look like and what information should be disclosed, whether some information about how to make a claim against the bond or what have you. The group is on board with not requiring malpractice insurance, but that doesn't foreclose the possibility of having a similar requirement that lawyers have, which is to disclose the absence of malpractice coverage. So I imagine, I think we've talked about that in the past, and I don't see there's any reason not to impose the same requirement upon paraprofessionals. So that would be Rule 1.4.1. There's some question about whether it should be a separate writing or not. So right now we're allowing lawyers to basically put that in the retention agreement. And it doesn't really, there's strong arguments that it's not that effective because of it's buried in those agreements very often. So, but
I'm sorry.
Go ahead.
Were you, just right here, I have some notes from your last meeting, just real quick. When you keep going back and forth between whether it should be in the written agreement, and then I'm assuming the other option is to be in the informed consent, I just wanted to make a comment, and that came up several times as you guys went through the memo, your memo, is that, in my opinion, the informed consent is standard, applies to every specialty, regardless of what your specialty is, then the written consent should be, or the written agreement should be special between that client and that paraprofessional, and things like maybe whether that paraprofessional has a bond and or malpractice. So these things, to me, should not be in the informed consent, if that's helpful at all.
Okay.
In my opinion.
Okay. So so your position is that they should each be a separate writing that has to be signed off on by the client?
So I believe that anything that is special between that client and that paraprofessional should be in the written agreement. All standardized disclosures that applies to every paraprofessional and every client that they assist should be in the informed consent. And then one step above that, it may be easier to have an informed consent per specialty, but then maybe not.
Okay.
As like a helpful template sort of thing, regional council forms.
Okay. Fariba, did you have a chance to look at, I drafted a new rule 1.5.2, which is the written agreement and informed consent rule. I
went through the recording, and that's one of the comments I made for your consideration, whether they should be put together or the written consent should be, again, special to that client and that paraprofessional, and the informed consent should be standardized. I think there was some talk about templates in that meeting, if I'm remembering correctly.
Yeah, I don't remember us actually, we didn't really come to, like, it's my recollection, Amos, that you did not have a strong position as to whether they should be separate writings or not, but correct me if I'm wrong.
I think they should be separate writings, definitely. I don't have a strong opinion of if one is a standard form and one includes all the specifics. I'm happy to, maybe we just start drafting and see what we look like, what an informed, because I do think there should be, templates, right, to make it as easy as possible. But I don't know if that means there's nothing to fill in on the template. But I do strongly believe the written agreement and the informed consent are two separate things.
Okay.
The written agreement definitely needs to be in writing. The informed consent, I do think it is a better practice, so I'd be fine if we agree that should be in writing as well. But it really comes from a different place and would have some overlapping things like not an attorney and general fees. But I think the main idea of the informed consent is to try to make sure clients or prospective clients have the information they need to make a decision and know what they're getting into, whereas the written agreement has all sorts of other bells and whistles and things could end up being buried.
Yeah. So I would recommend that we have the rule for what needs to be in the written agreement, what needs to be in the informed consent. The paraprofessional board can, draft a standard agreement and stating that use of this agreement is you will be in compliance with the rule if you use this agreement. But you're not required to use the form agreement. You can draft it. You just have to make sure you have all the elements that are in the rule, or else you may be subject to discipline.
Yeah,
so we need to, I think in rule 1.5.2, we would need to be clear that everything that's under subpart A is separate from all the required elements in subpart B, which is the informed consent. So to review right now, based on the original rule that you provided, Amos, the written agreement would include a clear explanation. I propose the alternative language from the Business and Profession Code, an explanation of the general nature of the legal services to be provided to the client. Also a clear, conspicuous disclosure that the paraprofessional is not a lawyer and may only provide limited legal advice, may not represent in court, and we're gonna have to decide whether or not that actually is true. And the additional information under 2, identification of the fees and costs that will be charged for the services. And I provided.
Sorry, Greg, are you in here?
Yes, I am. I'm on rule 1.5.2.
Oh, you're
sorry.
past it.
Going too far.
There it is. It's yeah.
Okay.
But there, yeah. Then slide down. So this first part A covers what needs to be in the written agreement.
Mm-hmm.
Okay. And this is, again, it's really, I was just taking the elements from the rule that was patterned on APR 28 from Washington that Amos had provided with some additional language that I think Amos included. And I have alternative language where you see that highlighted in yellow that I mostly took from the Business and Professions Code that imposes the written agreement requirement on lawyers in certain circumstances. So all of these elements would be included. If you go to 7, a statement confirming that the licensed paraprofessional has malpractice insurance. So this is a question that I have because we have a separate rule for lawyers under rule 1.4.2, which is just above this one, that requires disclosure of the absence of professional liability insurance. Do we want one, have a separate rule for that, like we do for lawyers, or incorporate the substance of that rule into this rule and make the disclosure in the written agreement? Or should this be a third writing that a paraprofessional needs to provide to a client in order to get their informed consent?
Let me jump in with a couple things. One, Linda, do you have this document? Because I want to take notes and I only have one computer today. So I'd rather you share.
I don't have the document. If you want to send it to me.
Can you send it to her? And then 2, we started off by saying that we were going to debrief on the meeting, and then go. And I feel like we're going deep into substance now.
Yeah. Well, one of the things in the meeting, the reason I got into this is because one of the things in the meeting we've approved now is that paraprofessionals will have to carry a security bond, mm-hmm. and that they will not be required to carry malpractice insurance. But it does inform, now we've taking that feedback, we do want to impose a disclosure requirement upon them. And I don't think we really came to a consensus as to what are we doing with the written agreement and an informed consent. Are there separate writings? Do the things that we have in the rule now, are those the things that you as a subcommittee approved as being in that rule? And how does this impact rule 1.4.2? Because that's a separate rule that requires another disclosure of the absence of malpractice insurance. I'm a little concerned about the clients being confused by all of this, basically, because when we take rules for lawyers and then we are imposing new rules, we're creating a bit of a hodgepodge. So I'm trying to figure out how to streamline this in a way that makes sense.
Yeah, and I'll say, I think we can go back to where we were, but on this specific point, at least my view is there should not be a third writing. It should fit within these 2 writings we're contemplating. As far as where it goes in the rules, I defer to your good judgment or proposal. I think last time you did have a 1.4.2 parallel, and I think we discussed cross-referencing that one way that could be done is in the written agreement. But you know, if you have a different proposal, I think you're the expert on
yeah,
sorry.
I would say that I would probably advise that we take the substance of what's in 1.4.2 and fold it into the informed consent aspect of this rule. And maybe this becomes 1.4.1, requiring a written agreement and then separately an informed consent. And the informed consent is a series of disclosures, including one, I'm required to carry a security bond. And perhaps this is the process for filing a claim against a security bond and disclosing that if you don't have malpractice insurance, that you don't have malpractice insurance. Mm-hmm. And that part of 1.4.1 is also this idea of an ongoing obligation to disclose later in the course of representation if you had malpractice insurance at the initiation and no longer have coverage.
I do like that better. And I think that really distinguishes the pre-engagement disclosures from the retention agreement. So I think that's better.
Okay, so that's the only thing.
I agree with all of that. The only comment I have, probably in minor details, is some paraprofessionals may choose to carry malpractice insurance. So if you put that in the informed consent, so my suggestion was informed consent have only statements that applies to every paraprofessional, right? So I have a bond, here's how you claim against bond, but maybe the malpractice piece, insurance piece needs to be either I have not in the informed consent, or it will be in the written agreement.
Well, so just so we're clear, for lawyers, they only have a duty of disclosure if they do not carry malpractice insurance.
Okay.
So if they're carrying it, they don't have to disclose anything.
So if it's in the informed consent and it's a template, what do they do? Cross it off?
It's just that we would phrase it as a conditional disclosure obligation. Yeah.
Okay. Thank you.
Okay, Linda, I am sending you.
I just got it. Thank you.
Okay. Okay. Let me reopen that. Is there anything else from the feedback that we got from everyone that you'd like to talk about in the context of the rules?
I think we haven't gotten into the fees yet, and this might be a question for Brady, but it sounded like at least several people thought there might be some antitrust concerns depending on which direction we went if we decided to regulate fees in either fee caps or other ways. So it might be a legal issue that we need some research into.
Well, it may have been me that actually, I think it was in the very specific context that was being discussed, that if lawyers are permitted to practice with paraprofessionals in the same firm, that law firm would not be subject to fee caps. But if paraprofessionals were practicing on their own, they would be subject to fee caps. And I was just positing it as a question of whether or not there may be some impermissible anti-competitive aspect to that type of arrangement.
And I think as a general question, it's come up, and we discussed the mid-cal factors, that the more state involvement, whether it's the Supreme Court or the legislature, setting the rates or at least setting very clear guidelines, then you're not going to have an antitrust problem. But if it becomes much more discretionary and a body has appointed attorneys and other market participants is really setting the policy, then that's where you're going to run into questions. So it more turns on the implementation than the concept of having a cap or not.
Do you remember if immigration consultants have fee caps? I don't remember in that legislation.
No.
They're barely regulated. Yeah.
Well, there's a new bill to give them a new name and have some increased requirements for them, but there's not fee caps in that.
Yeah, generally they're not regulated much at all, other than some disclosures now.
Yeah, so as a group that's so generally looked at as, predators of immigrants, they don't have fee caps. So I'm just wondering, what the discussion was around not having fee caps and kind of consider that when we are considering this group of professionals.
Yeah, so I'm happy to jump in. I think we're going to have a lively discussion about this issue, but generally speaking, I think the experience with immigration consultants and the need to regulate differently is part of the impetus for why we're here, and trying to address the problems that you have if you have non-regulation. So, I would say the same thing with all the regulation we're talking about in terms of education, licensure, discipline. All the regulation is, I think, to avoid what people see as what happens if you don't regulate.
Okay. So in terms of process going forward from here, I think I have good direction from you on the written agreement and informed consent aspects of the rules at this point. And we can revisit it later once we have an updated draft. I think we began to talk about the scope of practice rule that you provided. We could go through that as well as the prohibited acts language from that rule as well. I feel like we could do this, dare I say, quickly, because I do have a pretty strong opinion about how to handle these rules, because it's very similar to the way we handle our multi-jurisdictional practice rules under Chapter 9 of the Rules of Court. So for instance, like Rule 9.46, which is registered in-house counsel, we do have provisions under that rule that talk about these are the permissible activities that once you register, that registered in-house counsel can engage in, and this is, these are the prohibited acts as well. So one way I think we handle this issue is through a combination of both the rules of professional conduct and these rules of court. You set forth the scope of permissible practice as well as prohibited acts in the rules of court. And to the extent anyone engages in any acts that were prohibited or exceeds the scope of practice, they have now violated Rule 5.5, which is unauthorized practice of law, and are subject potentially to discipline on that basis. So in my memo, I kind of stepped through each of the provisions in your proposed rule, Amos, just to cross-reference where we are handling a lot of these more specific prohibitions in our rules of professional conduct. So for instance, on the scope of practice, this is kind of hard to do on because it requires us having 3 documents open at the same time. But the scope of practice rule that you provided, subpart 1 says that the paraprofessional should ascertain whether an issue is within their defined practice area for which they're licensed. If it's not, they should not render legal assistance on the issue and shall advise the client to seek services of a lawyer. If the issue is within their defined practice area, they may render the following limited legal assistance to a self-represented client. So the way I think it's best to deal with this introductory paragraph is through, and we may have started talking about this last time near the end, through Rule 1.16, which covers the duties and obligations of a lawyer at the when they are declining or terminating representation. And I think I misstated in my memo that I added A6, it's actually A5. So Linda, if you could bring up those rules that I just sent to you and then go to Rule 1.16.
So Greg, I keep doing this to you, but I just want to make sure that we're all clear what we're doing today. So today we're going back into the memo. We're not having the fee discussion, because I know Freebie, you said we keep saying we're going to get to it and we're not getting to it. I'm kind of feeling like, so I just want to make sure.
Get to the fee discussion?
Yeah, the fee discussion on fee caps. No, I don't know. I just want to make sure we are clear what we're doing. We could have a goal today of getting through what I'm calling getting through Greg's memo, which is all the different parts. And that's what we're doing now. We still have our policy question document to get through. And then we've got fee caps, like the big kahuna. Mm-hmm. So, and in a way, that's one that I think could be disposed of relatively quickly, because at the end of the day, I feel like it is, there are philosophical positions that people have. Then there's the practicality of how would you actually do it. Mm-hmm. If you're on the border philosophically, like if you're on the fence philosophically, you could be tipped based on practicality of implementation. But really at some level, like I think I know where the two of you stand on it. think the working group is probably split, and it may likely come down to just a vote.
And I have to inform you that I have moved my position a little bit because I think that imposing fee caps may be more practical for certain specialties than others, such as fee expungements or a UD answer or something like that. Family law, I mean, I can't even imagine, and that's my specialty. So I would be willing to kind of look at, those options rather than saying, oh, let the market regulate that, which I'm a proponent of. But I think that I would be willing to compromise there so that at least our subcommittee can come up with a recommendation.
Yeah, I do think I would like to see if we can come up with a joint recommendation, even though we do come from different places on this issue. But I agree that ultimately it's up to the full working group. But I do think we have work to do to see if we can come up with a recommendation.
So do you want to do that? Do you want to, again, I'm sorry to keep interrupting, but we can keep doing what we're doing, which is getting back to the Greg memo. We could go to fee caps.
I would like to see what we can do on Greg's memo and finalizing sort of all the stuff we've worked on already, and see how those go into the rules, because we may not be able to conclude the fee discussion quickly.
Okay,
I agree.
All right.
Okay.
So sorry, Greg.
Hopefully this will go quickly. So as you can see here under Rule 1.16, I added A5, which essentially mirrors the concept of what you're trying to get at in the proposed rule that you sent, Amos. So at the initiation of representation, the paraprofessional has to go through this process of determining that they should know or reasonably know that the subject of representation is beyond the scope of their defined practice area as set forth. And we're going to have a cross-reference here to whatever rules of court govern their scope of practice. And this may be, I imagine the way the rules of court are going to operate, or we're going to have a general scope of practice and permissible activities, as well as prohibited acts rule for all paraprofessionals, and then also have specific rules for each of the subject areas in which they may be licensed. So we may be cross-referencing multiple rules here, but we do want to cross-reference the rules so that they know I need to look at these rules, understand what the subject matter of representation is, and if the subject matter of representation is beyond the scope of their defined practice area, they cannot render any legal advice, and they must advise them to seek the services of a lawyer or a paraprofessional who may be able to provide those legal services within their scope of license. And violating that, you need to figure this out at the initiation of representation. If you continue to provide legal advice beyond the scope, now you've violated this rule and you've violated Rule 5.5 because you've now engaged in the unauthorized practice of law. Turning back, so I don't know if you have any comments on that.
I have a question related to this section, not an A 1.16A4. You all had a tiny little discussion, and Amos mentioned I had brought up an issue. And I was wondering if we're drafting this rule, maybe we can address this loophole that causes awful problems out in the field for us who are helping self-represented litigants. So it says the attorney is supposed to stop representing the client if the client discharges the lawyer, right? Unfortunately, CCP 284 requires consent of both sides. That's why the substitution of attorneys form has both a signature for the client and the attorney. And if there's a new attorney coming in, of course, that attorney. What happens out in the field is attorneys refuse to sign that form, whether it's because they're just spiteball or because the client owes them fees or they just don't care. We see it all the time. And there's no unilateral substitution of attorneys allowed under CCP 284. So that results in the self-represented litigant not being able to use self-help because we are statutorily not allowed to help people who have attorneys on the record. They have an attorney. And then also ties the hand of the counsel for the other party, if there is counsel, in the hands of the judge because the person is represented. So I've tried to write proposed legislation to get kind of fix it. It's in the works, but can we or should we address that in any way? Could we? I mean, I think it needs a change of legislation. You can't address it here. Some of
I agree with that.
Make it a, I'm sorry, I'll stop, but make it sort of like a violation of the rules not to sign that form.
Well, I mean, it probably is a violation of the rules and not, I mean, the attorney, the client has an absolute right to discharge their representation. So to the extent there are lawyers out there refusing to be discharged, arguably they could be subject to discipline, I believe, under the current set of rules. The problem with this is always you need somebody to actually refer them to the state bar. And the client may not be sophisticated enough to know that they have that avenue.
CCP 284, I just looked at it. It won't apply to the paraprofessional unless it's amended to do so, right? Because it specifically says an attorney. So if we intentionally don't seek an amendment to that statute, then wouldn't it not apply?
But that begs the question of, is the paraprofessional appearing, making a general appearance? Are they representing the client to the extent that are they allowed to represent? I mean, what does that mean?
I think we should take a note of this and put in and move it to the side for right now for you, because I think that this really gets again to what we're going to talk about on Friday in terms of representation in court. But I think it's an important point. I think we should definitely note it, and it may be one of those statutes that goes in the list of things that need to at least be looked at and decide whether or not there needs to be an amendment, either to permit, to acknowledge that paraprofessionals are going to be representing folks in court, or also that it sounds like this is something that is causing a problem practically for clients. But this is, I'll tell you, this is not the first time I've heard of a widespread practice by attorneys that arguably can subject them to discipline, but they're not being disciplined for it. And again, this is, I think, a breakdown in the enforcement level of the attorney discipline system and not so much in the rules themselves.
Yeah, and I'll also note this came up with this prior discussions with FREBA, and I think we made some notes in other rules. The contract, the written agreement and disclosures also might have a disclosure that you can be terminated at all time. And the question is that true? Or, in practical reality, how does that work? So I like the idea of, if the statute doesn't apply, maybe we could solve this practical problem here in the rules.
Yeah, we definitely saw that when we were going through the lawyer rules and talking about trust accounts, and uncovered the fact that there's a widespread practice among lawyers to get advance fees and not place them in trust accounts when they were earned, because they considered them retainers, which is, so, that it's partly educating lawyers as well as to what their ethical obligations are, and in this case, paraprofessionals.
Yeah, as far as 1.16, Greg, I like the way you've approached this. My only comment is something I mentioned last time, which is, if with all the cross references and disjointing these proposed rules throughout, my concern is it's not very clear what a paraprofessional can and can't do, or what's required. So I think we're going to need to develop some kind of simple, straightforward training and rules cross-reference, because I like the Washington state model where it's all in one place and it's very easy to read. Mm-hmm. When this gets disjointed, I think the worst concern is it's hard to understand, and people are going to get confused, and it's not going to get enforced unless we have some sort of way of bringing it all together.
Okay. And then turning back to the memo, so that focused on the introductory paragraph in 1, and then in terms of the specific types of legal assistance which that they can provide, again, I think these are the types of provisions that I would envision being in the rules of court, setting forth the scope of practice. I think I had some questions for you in my memo about some of the specifics. Yeah, I noticed that in the APR 28F, there are several items that triple LTs are permitted to do in Washington that are permitted here. And I don't know if you wanted to talk about the rationale behind that. One was that they can inform the client of and assist with applicable procedures for proper service of process and filing of legal documents, which is APR 28F3. But I didn't see that in the list.
Yeah, so my list was based not just on the Washington, but I think Utah and Arizona also had rules. And then there was something parallel in California, maybe for the immigration consultants. So I sort of just did what I thought was the best, list. But I think, depending on if you think it should be more specific or there should just be higher level, descriptions and then maybe a catch-all. As long, I just think it needs to be clear in the rules, in the court rules, what is permissible.
Okay.
Technically I like the more detailed, the better, but I don't know if that's right or not.
I think the big ones were that in Washington, they're allowed to draft letters setting forth legal opinions that are intended to be read by persons other than the client. And they're also allowed to draft letters setting forth legal opinions that are intended to be read by, oh no, that's the same. Yeah, so I didn't know if you had were you opposed to them being able to do that type of activity?
No, I'm not opposed. And I think the way I read it is it wasn't necessary to be called out.
Okay, got it. Okay. And then the last thing
I'm sorry, I just have a comment, real quick question. I'm a little confused because we are, under every specialty, we're developing a list of tasks and issues that they can handle. So is this a higher level than that applies to every specialty, and do we need it?
It is a higher level. It's something that these other jurisdictions have done. That's really a question for you. I think it would be helpful for them to, there are things along this performing legal research that would be true of all paraprofessionals. And I was envisioning that there would be at least one rule that just set forth in broad strokes, at least, what are the permissible activities? What are they permitted to do? Providing legal opinions is a big one. I mean, that's clearly engaging in the practice of law. There can be no doubt about that. I think also obtaining relevant facts and documents and explaining the relevancy of each document to the client is something that, I think it's instructional, at least for the paraprofessionals, to know what they're permitted to do. So that's the way I was seeing it. I don't know if you're opposed to that and you just want to have permissible activities set forth by each type of license. That's really up to you.
I agree with it. That reminded me about this previous discussion and why we had it. Just for a moment, I blanked out. But no, I totally agree. At the higher level, general sort of types of work, like, memorandums of appointed authorities and all the other things you mentioned are fine. And then beyond that, then they're directed to their specialty.
Right. Exactly. And just to be clear, Fariba, this is stuff we talked about before and included in the draft language. So Greg is sort of working on the more specifics of where does this belong? Where's a home for it? And if we want to tweak the language, but
yeah, you're not seeing it right now. But it's the scope of practice authorized by limited practice rule that Amos had sent around, I think, in November. So we're kind of coming back to that. Yeah, I imagine, our discussion on Friday, we're going to talk about in-court representation. So there may be situations where we're permitting in-court representation in one area of law for one license, for one type of license and not another. So we might want to include language unless otherwise prescribed under the applicable rule.
I think that would work.
I have two questions. Is there something else we should be putting on the screen right now, number one? And number two, it's not really a question, it's a comment. I've been looking at other jurisdictions' rules for another reason. And one thing I was struck by is, in general, with respect to the specifics of the practice area, there's a in the rules, there's delineation of what is not allowed, right? Not this exhaustive list of what is allowed. And that seems to me to make a lot more sense than the approach we're taking, because my concern is, what if we miss something? Yeah. Given, you know, in family law, we happen to have a bunch of specialists on this working group, but in other areas, we're doing our best, but it's highly likely, unintentionally, that something's missing. So what if you've inadvertently left something out that should be authorized and it's not? And you—
So Leah, can I just jump in for a second on this? Yeah. To basically underline and support what you're saying, which is, Leah and I talked about this briefly the other day, although it was brief because I was driving in the middle of a storm while watching car accidents happen live. But we had a brief conversation about it, and it struck me that I think it is really great that we've been going through every single line item of what potentially one could be doing, because that helps to inform our decisions about what one can do or not. So I don't view that in any way, shape, or form as a waste of time. I think it's been super important and something we should continue to do. However, for purposes of what gets written down in a rule, I tend to agree with Leah that it's easier to do it by exclusion, to say that one can engage in family law practice other than, and list the things that we're specifically excluding. I know there must be, some concern that we forget to exclude something, but I personally think the risk is greater the other way. But I'd be curious to know what everyone thinks.
So I don't think that's how other states have done it. I'd be interested to see if you could point us to where that is the case. That's certainly, so these rules are based in large part on what other states have done. As Greg mentioned, specifically Washington, but also some of the other states. I think you're right in the practice area specifics of what tasks are, the specific practice areas are recommending be included or not. This is different. This is at the higher level of generally what paraprofessionals are and what they're allowed to do. And I think it's absolutely essential that we be clear about that. Yeah. So I think that these comments might be better at the specific practice area of what's allowed and what's not in family law, or what's allowed and what's not in housing. But as far as the rules of court, we can't create a licensed program where the rules of court are not clear about what a paraprofessional can and can't do, in my opinion.
No, that's what we were talking about with respect to the practice areas. Not.
Okay, so that's not what this is. So this is at the court rule level.
I know, but Fariba brought up the practice specific. That's why I brought this up. Yeah.
And I'm just wondering if it's possible, for sure, we will miss something. Even in family law, I'm sure we didn't think about something. Is there a general provision that can put in, kind of like, if something is not mentioned, you're not allowed to do it? Of course, in language that Greg will think of.
I don't know about that. I know that in the rule that Amos, that I think you took from the Washington state rule, that there's a final catch-all: render other types of legal assistance when specifically authorized by the scope of practice regulations for the approved practice area in which the paraprofessional is licensed.
Exactly, and I think that's the catch-all at the rules level, and then each practice area, they have the harder job of the specific inclusion and exclusion that specialists would know about. Right. I think that's right.
I'm just looking at our rules of court, because I'm sure we're going to be guided in large part by our multi-jurisdictional practice rules, because we have done this before. We do have a scope of practice section in each of these rules, but they do tend to be more exclusionary, as Justice Petru and Leah are saying. So it's usually you're excluded from representing anyone but except the institution for which you're qualified to represent. So if you're in-house counsel, you can only represent them. And there's exclusions on court representation in certain circumstances and things like that. So that is—
yeah, I think it might be helpful to be guided by what other states have done. And I don't think it's just Washington. I think Arizona and Utah and California's statute about immigration consultants also, I think, details this in a similar way.
There are some
I feel like we're talking about two different things. One is this general high level. I would agree it needs to be delineated. One is practice area specific. And I think that's where what you outline is the excluded activities.
Yeah, I think that might be right too. Yeah, I agree.
So for example, you're saying that in family law, so we have a long list of excluded, included, excluded. So you're saying when it comes down to it, the final product, we only mention what's excluded.
Yes, and how we use our very robust and rich list is to develop the curriculum, to develop the
for this one,
right? Mm-hmm. It's really important for that, but at the rule and enforcement level, we're focused on what's excluded at the practice area.
No, I think that's a good idea, as long as when they're in school, they learn what all these other included areas are.
Yeah. I agree, although I'll just note there is a larger policy issue. I think some people are still focused on, somebody that assists with forms, judicial counsel forms mainly, and some other limited practice to be able to advise about those forms and those issues, as opposed to like an attorney who has sort of a general ability to practice law. So I think this is really one of those issues where it might be either practice area specific or really a conception of what we envision here. If it's somebody who's going to be handling trials in court and entering representation and being the only mouthpiece for the client, and the opposing side can only go through the paraprofessional, that's one model. Another model is it's somebody much more focused on assisting outside of court with filling out court forms and advising of what forms are appropriate and what other options they might have. And that might be a much more limited model in terms of what the catch-all says.
Are we going to keep working on the scope of practice rule, and what should we put on the screen?
Well, I in terms of how exhaustive this list is, I'm also looking at the our certified law student program, and we do have a list of permissible activities. So we do have a pattern for that in our rules of court as well. We could continue to go through this. I thought we could go through this quickly because I just wanted to show you my philosophy for how I was going to handle the rule that you had proposed, where it would reside, and maybe set aside for now the conversation about what should be included in this list, or should it only be based on what is prohibited, what is the prohibited scope of practice. We do have another rule that is prohibited scope of practice. And I think when we go through that, I've been able to crosswalk a lot of those prohibitions to rules of professional conduct that we have. So I think a lot of those things that are covered in the rule you proposed, Amos, and I don't know if we need to go through this now because I did write it through out in the memo, but a lot of them do exist in the rules of professional conduct for lawyers that I was envisioning we would carry over for paraprofessionals.
That's great. So are you saying that for those that have a rule of professional conduct, you don't think they need to be in the rules of court? Because I think what you basically said is your recommendation that these mainly go in the rules of court, and then there's cross-reference that there could be discipline as well, right?
Right, but prohibited acts is a little bit different because Linda, do you have the PDF of Amos's prohibited acts rule, or do you need me to send that to you?
I have that. Let me just find it and I can bring it up.
I can email it to you too because I have it right here. Let me see.
That might be a little bit faster than me going through the folders to find where it is.
Yeah, because it took me a while to find it too. It was from last year.
It's on our memo. It's a attachment to the memo.
Right. And I can find it that way.
Okay, just send it to you. While she's pulling that up, I can read out the first one so we can keep moving forward. So the first on the prohibited acts, it says in the course of dealing with clients or prospective clients, a paraprofessional shall not, and the first one is make a false or misleading communication about the paraprofessional or the paraprofessional services. That is really the subject matter of Rule 7.1 for lawyers. And so I think we could have I think it belongs in the rules of professional conduct. It's already is handled there. So I'm not sure that we need to handle it anywhere else except there.
Yeah, that makes sense to me. Again, my concern is that it's just disjointed, and I like the model where it's all together, but we'll just solve that with training materials or something else.
I think that's the best way to deal with that, because it's just, it will be more consistent with the regulatory structure we have for lawyers as well. So
yeah, that works for me.
Okay. B, which is making a statement you can obtain special favors or have special influence with court or government agencies. That's handled in a couple of different places in our rules of professional conduct. Rule 4.1, truthfulness in statements to others, as well as 8.4E, which is a misconduct rule that we have for lawyers that prohibit them from engaging in dishonesty. Additionally, there's a comment to Rule 7.1 that addresses misleading statements that can be interpreted as guaranteeing positive results. So we may want to have a similar comment for the 7.1 rule for paraprofessionals as well.
That makes sense to me as well.
Okay. And then moving on to the next one, C, this retaining fees or costs for services not performed, I think it's adequately covered under several rules. Again, Rule 1.5E, which is, we're going to talk about in a bit, which is the fees rule, and 1.15B, which is safekeeping of property and money for your clients. A lot of the trust account obligations are there. And then 1.16E2, which sets forth the obligations of an attorney at the termination of representation to return all unearned fees. So I think we can rely on those rules to handle this obligation. Moving on to D, again, I think this covers, that's also covered in Rule 116E1. You have to return unearned fees, and you have to return all the client files and any client property that you have been keeping for in safekeeping. So, and then E, represent or advertise in connection with provision of services, any other titles or credentials. That is actually covered for the lawyer rules in 7.1 and 7.4, although I think 7.4 is a rule about legal specialization for lawyers and special disclosure rules around that. I think we had decided to not obviously have a rule like that for paraprofessionals because their license is a specialization. So I think a lot of this can be covered again in comments to Rule 7.1, where we set forth specific examples of what would be a violation of that rule against making misleading or false statements. So we can make a note to include a comment there. And then moving on to F through H.
I'm sorry, instead of any rule, just have a comment? That
tends to, whenever there's a specific, and we moved it in this direction, especially with the second Rules Revision Commission, is to try to really make sure that the rules state a broad standard, disciplinary standard. And to the extent we want to highlight a specific instance in which a lawyer may violate those rules, that broad standard, we wanted to reserve that for comments, which are supposed to be providing interpretive guidance to lawyers. Rather than trying to make a rule for every specific example that we could think of that might violate what we really want them to not do, which is engage in misleading and false statements. And I think we're going to continue to move in that direction, actually, with the Closing the Justice Gap group is going to be looking at the advertising and communication rules again, because the ABA just, right after we approved our new set of rules, the ABA decided to amend theirs again. So we have to look at them in light of that. And F through H, I think is sufficiently addressed in our UPL rule, but we may again want to include some additional commentary because this is really talking about specific examples in which a paraprofessional may exceed their scope of licensed practice. And to the extent they do that, if it's If it's prohibited to conduct or defend a deposition under the rules of court, either the broad rule of court that we talked about that applies to all paraprofessionals or in a specific practice area, then they will have violated the UPL rule. And we can highlight that so that it provides the guidance that you're talking about, Amos, in the comments themselves, because I think the comments are very helpful in that way. So that's, I think that covers, well, no, do we have a couple more? Okay. Regarding I and J, I think those should be included in the rules of court, setting forth the permissible scope of practice for all paraprofessionals. That's what I stated. So that we just talked about that. K, I don't think this is necessary, and I'll tell you why. Because I think Rule 1.1, which is which is the competency rule, I think it sets forth that the scope of. I'm sorry, it's not the competency rule. It's the rule. It's 1.0. It's a rule that defines what the purpose of the rules of professional conduct are and makes clear that any violation of these rules will result in discipline. So I don't think we need to repeat the fact that if they violate a rule of professional conduct, they may be subject to discipline, because that's actually covered under the general scope rule that we have, 1.0. My memo, I said 1.1, but that's incorrect. So that's my feedback on those particular rules. I don't know if you have any additional comments, or do you want to move on to the fees rule?
So do you mind if I just address this? So I agree with everything, Greg, that you are recommending. I think this is great. You know, again, high level, what we had proposed in our language was tracking what other states have done with very clear rules, which would be, I think, equivalent to our court rules in terms of the scope of practice, what is allowed, and the scope of prohibited acts, which are not allowed. I think your recommendation, it boils down to the scope of practice, what is allowed does make sense in the rules of court. The prohibited acts list does not make sense in the rules of court and are covered by the disciplinary rules, which generally I'm fine with. Again, I think what that then is missing is the notice very clearly in the court rules about what's allowed and what's not allowed. But I think you're right that it's covered in the disciplinary rules. And there might be some other way we can really clearly convey that information to practitioners.
I don't think that captures my position entirely. I do think that certain prohibited acts, when you're prohibiting certain types of practice activities by the paraprofessional, I do think those should be in the rules of court, similar to the way we deal with them in our multi-jurisdictional practice rules and the rules of court. So setting forth the permissible scope of practice as well as prohibited acts. But in terms of the disciplinary weightlifting part of it, a lot of it is really handled by Rule 5.5. Because if you're in the rules of court, you're setting forth, this is what you can and cannot do. And to the extent you violate that rule of court, you're actually violating the rules of professional conduct as well. And that's what's going to subject you to discipline.
Okay, so maybe what I will recommend, I again agree with everything you're proposing. I think the entire draft prohibited acts language that's on the screen, all the way A through K, all of them except for conduct a deposition or initiate or appeal, you're recommending that we don't have in the rules of court, right? So I guess my question would be, what prohibited acts would go in the rules of court? And maybe that's for us to just think about separately, because
I do think it's for us to think about. I mean, one of the things that we're going to talk about is in-court representation. If the group is really going to recommend broadly that paraprofessionals cannot represent anyone in a court of competent jurisdiction in California, that probably should appear in the rules of court. And that would be beyond the scope of their practice. I don't know if conducting a deposition may be another. I think we need to think about what types of activities we do want to prohibit in all circumstances paraprofessionals from engaging in.
Okay, and I think the reason I'm raising that is I think that's for this group, obviously to get direction from the full working group in Friday's discussion, but ultimately the drafting of the proposed rules and proposed, you know, either scope of practice or prohibited practice in the rules of court. I think we are tasked with at least, you know, making an initial recommendation based on that feedback.
Mm-hmm. Can I ask a question just because I'm not sure I'm exactly understanding it? So everything that's in the draft prohibited acts, like the Amos's document, the recommendation is that it either be addressed through, it already is addressed through an existing rule, or it be addressed via a new comment in the rules, or for two of these items that they will be addressed via the scope of practice rule, right? And then Greg, you're saying that some things ultimately could make it into the rules of court as a prohibited act. For example, it's prohibited for a paraprofessional may not represent anyone in court, for example. What I'm not tracking or understanding is like, why would that be in a rule of court, not in a rule of professional conduct? Because obviously we want someone to be able to be disciplined if they represent somebody in court, and they shouldn't have. And I guess they would as UPL.
Right.
So,
well, yeah. the difference in my mind is I'm trying to draw a distinction between what would essentially be an ethical violation as opposed to what would be a violation of your license. So, so if you can imagine all the things that lawyers are permitted to do that we do not want to permit paraprofessionals to do, I envision should be in a rule of court that defines what the scope of the license is. So that to the extent that we're trying to provide a description of the contours of the license, I think that should be in a rule of court in one place, as Amos has been saying, one place where paraprofessionals can say, here are the things that I can and cannot do. And it's part of my license. I have to meet these educational requirements. I need to pass this test. And once I pass that, these are the things that I can and cannot do within the scope of my license. Making a false or misleading communication, it has nothing to do with that necessarily. That's an ethical obligation. And that really belongs in the rules of professional conduct. The way these two tie together is really when someone exceeds what is the scope of their license as set forth in the rule of court, knowing that they are engaging, that they should reasonably know that they have a limited scope of practice, and yet they go beyond that scope of practice. Now they've wandered into the ethical territory, an ethical violation of their obligations as a paraprofessional. And so I think it's important to draw that distinction, because the rules of professional conduct, any violation of the rules of professional conduct result in discipline. Other rules that we have in the rules of court that lawyers have to operate under don't necessarily result in discipline. They have other results. So for instance, if you fail to meet your continuing legal education requirements, you're not necessarily disciplined, unless what happens is you're placed on an administrative suspension until you bring yourself into compliance. Okay, now you're on administrative suspension. If you continue to practice after being notified you're on suspension, now we've wandered into the ethical violation area. So I think it's really important to create this separation between our ethical rules and these rules of defining the scope of license.
Okay.
That makes sense. And my issue with this rule, my only issue with this particular rule was, it seemed to me the way I read it, it was mixing them together a bit. And that's the approach that Washington took. And I think maybe, Amos, it was because, as you said, it makes it easier perhaps for them to comply if they seek it in one place, all the things they can and cannot do. But we just haven't taken that approach here. We've really been trying hard to make that separation between what are the disciplinary standards that lawyers have to comply with, and what are these other obligations and with different set of consequences that they need to comply with.
And just to make it clear, I totally agree with you. I mean, I think my preference, if we were writing on a blank slate, is the approach taken by the other states, not just Washington, but Utah and Arizona as well, to have these all in one place, and I think easy to read and understand. But I agree, that's sort of California's model, and that the Supreme Court has spoken on this issue. So I think we know where they are, and I think you know where they are. And I don't think we should. I think we should follow your recommendation on this, with the understanding that we still should develop some sort of clear overview of what is allowed and what isn't allowed. Because I think that's kind of the most, one of the essential parts of regulation is making sure that's clear both to the paraprofessional and to the public.
And hopefully that is made clear to them as they meet their educational requirements to become a paraprofessional in the first place. Because they do need to have this, and this is really going to be the subject matter of their professional responsibility courses and tests that they need to take in order to get their license in the first place.
I just want to add in that I agree with everything as well, and I appreciate all the explanation. I know a lot more than I did before. And I think that, paraprofessionals, if we do it this way, which I agree that we should, paraprofessionals will learn in school. They'll get a cheat sheet, they get all kinds of guides, right? The public, members of the public never read these things anyway. So they just know something was done wrong, and they often don't complain. And by putting something in the maybe informed consent or some public outreach, this is how you can file a complaint. Honestly, when I tell people they can call the state bar complaint hotline, they have no idea. What is a state bar? So some outreach needs to be done. So as far as I'm concerned, this is fine, and it saves a lot of work as well. Create a brand new thing.
Greg, in your memo, I think you made a recommendation. We may also wish to address whether a paraprofessional can prepare a client for deposition. You also had a comment on the appeal. Do you want to talk about that stuff now, or is that now getting into the details of these things that we might want to talk about later?
Well, I'll be guided by you all. That was just a question because I just wanted to make sure that there's some thought went into whether or not this group was going to recommend that they have any level of involvement in those activities.
Yeah, so I'm going to suggest we wait to see what happens on Friday, because I think that might give us more clear direction, because a lot of these are, I don't know, it could go different directions. Right. on how broadly we envision the paraprofessional's responsibilities.
We're talking about I and J on the prohibited acts document.
Yeah, in Greg's memo, he made some recommendations about additional detail that we might want to include on those.
Yeah, because I think that in each specialty we talk about, I don't remember if we talked about appeals, and I think that maybe, what was your suggestion, Greg? My apologies.
Well, no, it was not a suggestion so much as I just wanted to point out, initiate and respond to an appeal to an appellate court, whether or not we wanted to provide additional guidance as to what exactly that meant. I'm not sure it may be clear to a paraprofessional what, does that include helping a client draft their own appeal to a decision, and whether or not, if we're going to say that they can't have any involvement in that whatsoever. I was just concerned that this language wasn't specific enough.
And I don't remember talking about appeals in, for example, family law group. I just don't think we've talked about it. And I don't know if it's a higher level issue, like in court representation, that no subspecialty should include representation in court, for example. Or is it going to be per specialty that they could do some? I'm sorry, go ahead.
I think it's going to be per specialty. I don't think there's been any decision made that it's off the table. In fact, I think now I'm forgetting which subgroup, but there was a discussion about this. Perhaps Leah recalls, but I don't recall which one it was.
I don't think we've actually talked about two in appellate court. We've talked about the small claims appeals, right? But
right, and we've talked about, we've talked about enforcements of judgment, and I'm trying to remember.
It wasn't a part of family law discussion?
I don't recall, and I actually coming up with some opinions about that as far as partial assistance with some forms. There's some judicial council forms, but not anything else. I don't know. I mean, we should bring it up, really.
Yeah.
Are we at a point on this scope of practice discussion where it makes sense to send a document or something to the committees to say, this is what we're thinking about on a general idea, but your committee is tasked with deciding what's appropriate in your practice area? Or because it feels like we're doing this independently, which makes sense at the beginning, but it sounds like we're coming up with, here's what we're proposing for general regulation, and you need to consider what's appropriate in your practice area.
Maybe so after Friday's meeting, to revise it to reflect that and then send it off. Because there's been a lot of discussion about depositions. Right?
What's that?
There has been a lot of discussion about deposition,
yeah, it has been, yeah.
but not the other.
So I don't think the deposition one is a high level. Well, if every group decides that there shouldn't be, paraprofessionals should not be allowed to do oral depositions. I think in family law we decided that. Then it becomes a higher level one, right? Because none of the subspecialties are allowing that. I think the appellate one, we really forgot to discuss it, truly. At least in family law. We haven't gotten to in housing, we just started meeting.
And that's actually why I think maybe we send something out, because like in housing, we're very generally just starting the task list, but we, you know, depositions haven't been brought to our attention. So we haven't, you know, I think this might specifically call out or start some of those discussions.
And I think in family law, there was discussion about the extent to which they would be permitted to propound and respond to discovery, written discovery as well. Right,
absolutely. And I believe, I don't have the list in front of me, but I believe that oral discovery was excluded. Depositions were excluded.
So this may be, I mean, we may be making a list based on all of the different specialty areas. If there seems to be consensus across the board, for instance, that paraprofessionals should not conduct or defend depositions, that this becomes an item that we list in the broader rule as a prohibited activity.
And Amos, I think that IRA did flesh out the discovery portion of our housing, in the housing committee. I don't have that list in front of me either, but I think that he suggested that we exclude oral discovery.
Oh, I didn't notice that. Great.
I'm sorry I missed it earlier. Here, the J, initiate or respond to an appeal to an appellate court. Is it sufficiently clear that that really means a separate court of appeal as opposed to the appellate division within the superior courts? Because those are two very different things.
Yeah, it's not clear to me.
And we could take a look at, you know, there are only certain things that would even go to an appellate division within a superior court. So maybe it would be irrelevant based upon the subject matters. I just can't, I can't say with certainty as I sit here, whether there's anything in the subject matters that we're currently contemplating that would have a right to go to the appellate division. I think there may be with collateral criminal.
And small claims, I think a couple.
Small claims. Oh, small claims for sure. Yeah, absolutely. Yeah. So anyway, I would just say that we want to be clear about whether we're talking about the appellate division of the superior court or, you know, the appellate panel, whatever they want to call it, in the individual superior court versus an actual court of appeal.
The only other thing that also occurs to me is that we are permitting paraprofessionals potentially to represent individuals in administrative agency proceedings, which I'm not sure if this includes helping them prepare an administrative mandamus.
Right. And I do think this might be different subject matter because, you know, Amos just helpfully reminded me about small claims, which actually is a good bulk of what shows up in front of the appellate panels of the superior court. And I suspect we would want to allow, you know, paraprofessionals to be doing that. But that's different from, let's say, family law appeals that go to the Court of Appeal.
Mm-hmm. So I'm wondering if with this particular rule, if it's probably more helpful to really wait until we see what each of the different practice areas come up with in terms of defining the scope of practice.
I agree. So that was really my comment, which it looks like most of what was in this, you're finding that it really should go in the rules of professional conduct as disciplinary issues. But I think we should still have a conversation about scope of prohibited acts in a scope of practice rule that goes in the rules of court.
Well, just to be clear again, what I'm suggesting goes in the rules of professional conduct are the items here that already have a counterpart in the rules of professional conduct. but there's nothing like this, conduct a deposition, initiate an appeal in the rules of professional conduct, unless you're doing it frivolously in some way. So I think that these last items that we're looking at right now definitely would be in the rules of court, defining the scope of practice broadly. But it sounds like we probably should wait to even endeavor to put together this list until we see what the different practice areas come up with.
Right, but I think, Amos, you were suggesting sort of prompting that by sending out the draft scope of practice rule, right? And so what I'm wondering is, should we pull that up now? It sounded like, Greg, you identified some things that were missing from Amos's draft. Amos explained why. I think because you were saying, Amos, you didn't think it was necessary, not that it was intentional. I don't know, but should we do that so we know? And then where's the placeholder for what would be modified based on Friday's discussion? And then we know what we're going to send out to the practice area subcommittees.
Yeah, so I think that makes sense. But again, just to be clear, I think the other states that these drafts were fashioned on had both what's allowed and what's not allowed. And so when we look at the scope of practice right now, that is just based on a draft of what's allowed. There's nothing that's listed there that says what's prohibited or what's not allowed. And that's where I think we need to put our thinking caps on and have that discussion. I'm fine waiting until after Friday, but right now we don't have a draft of that.
Yeah.
Other than depositions and appeals, which we need to work through a bit.
Well, we have it for family law in all the excluded tasks, which some of those tasks are can be broadened, I think, to cover one of these categories. We have it in, I think, collateral criminal. It was done. It's moving along for each of the areas, I guess I would say. The list of excluded, their tasks, they're at a more detailed level.
Right, but just to use depositions as an example, I think we're siloed in the practice area. So it might be that family law has decided depositions should not be allowed because paraprofessionals shouldn't do them. And housing might come to the same conclusion, but a different practice area, you know, if we're not talking to each other or have a draft rule, may come to a different decision. And that's not necessarily because it's appropriate in that practice area and not in others. It's just because we haven't we're not talking to each other. So I think as a regulation subcommittee, I would like for us to try to start compiling that list of what might end up in the rules of court as prohibited acts.
And some of those prohibited acts are based on the skill set needed, kind of like in-court representation, jury trials, and oral depositions. I mean, we're talking sort of the same skill set. So that's why I think there would be on a higher level rule of excluded tasks. Then others are really specific to the practice area. I think appeals may be something that could be also at a higher level, but for the appeals to the Superior Court panel.
Right. So right now, I think the only three that are on my list for discussion of potential inclusion are depositions, appeals, and we'll see what they say about in-court representation. But I think, again, that's the start of our discussion. There might be other things that we should at least consider.
There has been some discussion about the ability to negotiate with opposing counsel to settle a case as well, as I recall.
Although my sense is that's going to be included, not excluded.
Mm-hmm. But for the point that Justice Petrov brought up yesterday, in that there's negotiations are only good if there's the threat of going or possibility of going to court, right? The realistic possibility. So in the housing context, as we talked yesterday, because of the shortened timeline, the very first time that you go to court is trial day. So if the paraprofessional cannot represent the client in court, then there's not going to be effective negotiation either.
Yeah, Justice Petrie, I don't know if you're already have Friday's meeting planned out and how we're going to attack in-court representation, but it might be worth having a discussion of negotiating with the other side as part of that as well.
Well, yeah, yes. I mean, as it comes up, I mean, what came up yesterday was specifically the ability to go to trial, quite honestly, as opposed to the broader in-court representation, because we were discussing unlawful detainer matters. And the reality that usually counsel on those cases don't even see each other or have any interaction until they're standing there about to go to trial, and that it's the pressure and the ability to say, oh no, I'm ready, let's go, that leads to resolution and the difficulty of doing it otherwise. I actually, for the in-court representation, I think what we'll do is wind up with a default position that a number of people will disagree with, and then individual groups will have to make recommendations based on their subject matter. I very much doubt that the default position is going to be that paraprofessionals can go to trial, certainly in front of juries. So I don't quite know how we're going to square that with the unlawful detainer matters. I think we're more likely to find a default position of in-court appearance has to do with, hearings and status conferences and those sorts of things. But that's my reading tea leaves.
Right.
So where do we want to go from here? I keep looking at the certified law students rule, because really the big subject areas for permitted activities have to do with conducting depositions, appearing in court, and negotiating, subject to a lot of restrictions. So
yeah, we might want to look at that. I have not looked at that for guidance for this, but that might be a good model to follow as well. Again, we might not end up with the same recommendations, but it might be a rule for us to look at as a model.
And if you do that, I would suggest you just look at all of the rule 9.40 et sec rules, because there's different restrictions for military counsel or in-house registered in-house counsel or pro hac vice. There's different ways in which we set those restrictions and permitted activities.
But for the most part, Greg, where I think we are is we're agreeing with all of your recommendations. I think, there are some comments and notes, but it sounds like you probably have enough to take the next step of moving those rules forward, right? Or is there anything else that would be helpful?
No, I think I agree with you. I think I have what I need there. We do have, what do we have? About 35 minutes left to want to talk about the fees rule. And I guess this could lead us into the fee cap discussion as well. But if you turn my memo, I think I dealt with that particular issue first in my memo. So I think we've talked about this before, but I think we need to decide, because the rule as drafted, and granted that this was the rule that you gave me back in October. So it was before we had a lot of conversations about this, but it seemed to use both the term unreasonable and unconscionable in the same rule. So Linda, could you pull up the fees rule that Amos provided to us? And again, I think this was based on Washington State's version, APR 28.
So I'll just note, as far as the draft fee language that I circulated, that one was not agreed to by FARIBA. That was sort of an initial draft. All the others were sort of hashed out. And that was actually not based on Washington's rule. That was based on California's rule for attorneys. Right. And I don't think FARIBA and I are on this in agreement on that. So I don't know. I appreciate what you did here, Greg, and I'm happy to talk through it, but I still think we have more fundamental issues, and we're not at the drafting rule stage in terms of any type of fee limitations.
And I don't think I have, because they were not included in the memo.
Oh, okay.
Right, because they were not agreed to. Okay. We did not forward them on.
I think we should talk about this unreasonable as opposed to unconscionable issue, though, because it's a pretty fundamental policy decision. To the extent that we're to the extent we're adopting the ABA model rule standard of prohibiting unreasonable fees and subjecting paraprofessionals to discipline for charging unreasonable fees, that's going to be a significant, that's going to create a significant difference between the rule that applies to lawyers and the rule that applies to paraprofessionals. And I think I've talked about this before in the larger meeting as well, but we can, let me just send this to you.
Yeah, and so let me take one step further back. And again, I think follow up on the full working group discussion, because I think discipline standards based on reasonableness of fees is one option that we discussed. And Greg, you've expressed some concerns about how that would play in California, since that's not how we do it for attorneys. Another way to regulate is just to have some sort of fee schedule or fee caps, which I think wouldn't be a disciplinary rule. That might go in the rules of court. Again, I think that might be open to discussion, but at least as I understand, Greg, the distinction you've made, that would just be regulate, you know, that would just be a rule, and still there might be some disciplinary consequences of that, but fundamentally that's not a rule of professional conduct, that's a court rule. And I think there's other alternatives. You know, I think the working group now has approved a mandatory fee arbitration, which I think plays into this discussion a bit. But again, fundamentally, I don't know if we're ready to start drafting disciplinary rules or rules, because I just don't know if there's agreement, whether we should just not have any regulation of fees, or track attorneys, which is unconscionable. But I think we've noted in the past that the unconscionable factors, most of them don't seem to really apply to paraprofessionals, and I just don't think that's effective regulation of fees. So sorry to digress even more, but I just don't know if we're ready to draft rules on this yet.
Okay.
But when are we going to be ready to?
Yeah, I think we need to. I think we're going to have to. So that in terms of the unconscionableness factors, they may or may not. I think several of them will apply to paraprofessionals under Rule 1.5. Again, I think the main idea here with unconscionability, it's a policy decision that was made by the court that we can't subject attorneys to discipline for everything. We have to reserve our limited disciplinary resources to reach the type of conduct that we do here, which is unconscionable fee charging. And that really always has some element of overreaching on the part of the lawyer. There's usually some additional conduct at play here where the lawyer has engaged in fraud or deception of some kind. And so the factors that are listed under Rule 1.5 are a non-exclusive list of factors. We do have lawyers that are disciplined under Rule 1.5 rather frequently, but we don't go as far as most jurisdictions. I'll just say that, you know, Texas also joins California. I think Florida also incorporates an unconscionability or overreaching definition in its disciplinary rule as well. So that's regulating a lot of lawyers in this country under the unconscionability factor. Unreasonable fees, mandatory fee arbitration seems to work very well in that regard, because those are really just disputes over whether or not an attorney is charged a reasonable fee, either on an hourly basis, or they charge too many hours for a particular task. And we just didn't want to bog down our disciplinary system with handling those types of disputes. But we also wanted to give clients a forum where they could redress those legitimate grievances that they have with a lot of lawyers. So compelling lawyers to engage in arbitration when demanded by a client, it seems to really police that very well in California, as far as I think the court is concerned. Right now, under the draft rule that we have up, we have both the unconscionable term under one and unreasonable. I don't think the two of them can exist in the same rule. We would need to choose between one or the other.
Yeah, no, and I think that is very helpful background and really should guide what we do, because that's sort of a position that the Supreme Court has taken, and it distinguishes us from other jurisdictions. I mean, again, I think I'm at a different place, so we don't have agreement. So this is just my opinion, is that I think we should be looking at fee caps or specific regulation of fees in the rules of court, at least for certain practice areas.
Let me just build on that, because I should have probably added that as well. So to the extent that the group decides to recommend fee caps and the court and maybe the legislature agrees with that, that would fall under charging an illegal fee. If so, that remains a part of the standard for both attorneys right now, and as contemplated, I think, for paraprofessionals as well. So to the extent, and we get these cases quite a bit, lawyers who violate the rules and statutes we have around fee caps in micro fee caps or in the workers' comp context, loan modification rules. We do see those, and that's really under a different standard that has nothing to do with unconscionable or unreasonable. Those are just simply illegal.
And I'm having some internet issues, so I didn't quite hear all of that, but I think I agree with that approach. If there is some sort of regulation of fees, that the discipline would kick in when you violate those rules, and that's easy. That makes our job easy on the discipline side. I just don't know if we're going to get to agreement on fee restrictions, or if we do, it might be practice area specific. So there might be some practice area that doesn't have those fee restrictions, and that makes it, I think, more complicated for what we do.
Okay. Wouldn't that be a default rule that says no fee caps unless the subcommittees decide? Could we trust that the subcommittees can come up with that?
So at least in the housing subcommittee, the tentative decision, and that might change, was deferring the fee caps to this group or the larger group and not handling it the subcommittee. But again, we could kick it back. But I think Greg is really asking a more fundamental question, which is, do we want there to be a rule of discipline for unreasonable fees, which would be a departure of how we handle it for attorneys? And frankly, I don't think it would be a very helpful departure, because what does reasonable fee mean? If we're just incorporating the same unconscionability factors, I don't think that change. Personally, I don't think that's a really, I think that's probably not effective, and maybe wouldn't pass the Supreme Court anyway, because it's getting into business we don't really want to do. So I just don't even know if we want to go down that road.
Mm-hmm. And that was my thought as well, because since we like unconscionability sort of tested, and we should stick with it. Why create more work for ourselves when we haven't even looked at fee caps? And that's, and but aside from that, Amos, in terms of me and you coming to some sort of agreement on this, I'm just asking you if you would be comfortable that the default rule would be no fee caps and leave it to the committees, kind of like what we did with, the bond issue, the amount of bond issue. Would you be comfortable with that?
Well, I don't think I'm comfortable with that, because I think family law is the exception. I think all the other practitioners probably should have a fee cap. And so which is the default rule, I guess, is my thinking. I am fine if there's a different rule for different practice areas. I think that probably does make sense. But again, at the higher level, I think there's a question of if there's regulation of fees, how are we accomplishing that? Some concerns about antitrust, some concerns about this, discipline might not be an effective or the right approach because it clogs up the system and it's not the way we approach it for attorneys. So what would it even look like? And how, I think some commentators said it would be really difficult because there's different counties and different practice areas and different tasks in practice areas. So what would it even look like? And so some practice areas, it may just be difficult, or we might decide not to do it. But I think there's some practice areas, like housing, like consumer debt, like collateral criminal. And I think everything that I've seen that we've talked about so far besides family law. And honestly, I don't know that I'd be in favor of a paraprofessional working group proposal that doesn't have some kind of fee caps.
Mm-hmm. So to me, like the first question is, even if we were going to have a fee cap, would that be legal? I mean, that's my first question, because I keep hearing, oh, antitrust concerns and so on. That's, you know, that's not my forte, so I don't know. And then, Greg, you talked about illegal fees rules because there are already some fee caps, like I think workers' comp has a fee cap, right? How are those legal?
A limit on their recovery, the percentage of recovery for that workers' comp attorneys can receive, yeah. And it has to be approved, I think, by the appeals board.
They're set in statute, right?
Yeah, I think didn't Steve Flashman send around a...
Yeah, they're set in statute. I think, but the issue on the antitrust is, like, the state bar can't set these. They got to be set in statute or set by the Supreme Court, independent from the bar.
Yeah.
The court rule would be okay, it sounds like.
Probably the court would like the legislature to do it.
Yeah.
This, it really doesn't, I don't think imposing fee caps necessarily intrudes upon the court's inherent authority over the regulation of the practice of law. It's really, they're putting a limit on what the price that lawyers can put on their services under certain circumstances. So,
and they do that, I think.
They do that, and
they do that already in existing. I don't know if it's done by the Supreme Court or local courts, but there are fee schedules that are set by court rule.
Yeah. And again, once those limits are set, and if a lawyer violates, I'm sure they're subject to discipline because they're charging an illegal fee at that point.
Mm-hmm. And the fee schedules set by local courts those are court-appointed counsel. Mm-hmm. So that's the fee that you get if we're going to appoint you. It's not what your client is paying you. It's court-appointed counsel. And and I think like what we've heard on workers' comp is that structure has this unintended negative consequence of having people take tons and tons of cases. Mm-hmm. And that's what we heard Linda and I when we were developing 100 years ago, the dependency counsel rates, like the flat fee rates, that they were awful in terms of creating this economic reality where you had to take hundreds of cases in order to make a living. So I guess I'm wondering if having a more restrictive fee rule than what is in place for attorneys, if one reason for that might be that we are not going to impose fee caps, but we are going to have a more stringent rule. Like as we were talking, I was thinking, could one of the unconscionability factors, I don't like this factor personally, but
a lot of them are from the ADA model. I'm sorry.
I was going to say, could one of the factors be you can't charge, it's unconscionable to charge more than an attorney in your area might charge. Okay, forget about it's unworkable and whatever, but let's just say that would be unconscionable. It's unconscionable to charge someone who qualifies for free legal services if you know that they do, or if you haven't disclosed that option to them. So I was thinking about, is there a way to create a rule that gets us away from fee caps, but is more stringent than what we have in place for lawyers, which is really in reality not much.
And I think that is what Greg tried to do with his draft of what a reasonableness. So I don't know if that makes it unconscionable, but it might make it unreasonable. And that could be a factor. But again, it's kind of an ambiguous factor. You know, there are attorneys in Los Angeles that charge $1,000 an hour. So a paraprofessional, could argue, charging $600 an hour is a bargain. Who's going to identify what what lawyers are available at what price? And is that really a workable solution to this? If it's in a disciplinary rule, does that provide any real meaningful consumer protection for excessive fees?
Yeah. And I have to, sorry, go ahead.
I'm sorry. I was just going to say one thing that just to kind of peek behind the curtain in terms of what the Rules Revision Commission wrestled with when they were dealing with this and whether or not we should follow the national standard of unreasonableness. The more you dig into the case law in these different states, the way they interpret unreasonable in a lot of these jurisdictions looks a lot like how we interpret unconscionable here. It's just, at a certain point, it's semantics. And I think part of the problem with changing is we've been using that unconscionable standard for decades. I mean, for so long now. And there's obviously some concern that we may be signaling a change in standard by changing the term. And I don't think we wanted to do that. So to the extent that we're changing it, using an unreasonable term as opposed to what we use for lawyers, that would seem to indicate that we're applying two different standards. And
I agree. I'll say, but I like the thinking, because that is, we have to sort of figure this out. And I'll say courts set fees all the time. Courts, allow recovery of reasonable fees, on Lodestar, and, figure out the hours and figure out a reasonable hourly rate. They do that all the time. It's not necessarily a hard thing to do, but I do like, I would like this to be as simple as possible, that, simple and enforceable and meaningful consumer protection if we're going to do it. And I agree with Greg that monkeying around with the rules of professional conduct and having it be a disciplinary factor, that's probably going to be a difficult road to go down anyway, and may not solve the problem.
Can I just chime in for a second? The reasonable fees and the court's setting it. The court's not so much setting it as determining that it's within a range. And I think that's a different exercise. I think, for example, a court would be hard pressed to say how much should be the hourly rate for this is a very different and much more difficult analysis, as opposed to the attorney saying, I have done this work, I charge $400 an hour. That's in the range of something that is reasonable within the field. I mean, just to say that I think setting a cap is difficult. I mean, it's difficult to say what that number, whoever's doing it, however it's coming out, I think that's a difficult process that also, of course, then has to have built within it some ways to do adjustments moving forward.
Mm-hmm. And I also would not want to kind of create examples of this is unconscionable, this is unconscionable. And I especially don't want to, and I hear, and this was discussed yesterday too, that low-income litigants who qualify for free services should be put in this group to be especially protected. I look at it as taking their choice away from them. Some low-income litigants would like to come up with some money to hire somebody of their choice, rather than saying, oh, you have to go through the public counsel, or you have to go through legal aid, or maybe they don't want to. And by limiting the paraprofessional from representing them, then we're taking the choice away. I just want us to stay away from that. If a low-income person wants to borrow some money, or has a rich uncle or something who can give them some money, then we should then, take that choice away from them. I think that's going to be just not right to do. And I just want to take us back to sticking with the formula that works. So if unconscionability standard has been tested and works, I would say these are providing legal services. Let's just apply it. And I just go back to saying, let individual subcommittees determine whether they want to set fee caps and what that's going to look like for their group.
So I agree with respect to the discipline and the unconscionability, but I think the concern, I think the housing subcommittee group and your specialty, that might be right. But I think where the discussions have gone with housing and consumer debt and collateral criminal is these services are available for relatively low cost, something on the order under $1,000. Something on the order of $800 for a consumer debt attorney, full scope representation, something on the order of $500 to $800 for a housing, a tenant defense. And so if the goal is to create a low cost alternative to hiring an attorney, having paraprofessionals not have any kind of fee restrictions and be able to charge, $100 an hour, $200 an hour for a housing case where they're going to spend a lot more than they would have if they, engaged in a lower cost attorney that may be available, is a problem that I think we're closing our eyes if we don't address. If the real purpose of this program is to provide access to justice to people who can't afford an attorney, and we have to address the concern about excessive fees in some way. And again, it might not be across the board, but for housing, for consumer debt, for collateral criminal, to say that there is a regulation for unconscionable fees, I don't think meaningfully addresses the concern, in my opinion.
And you don't want to leave it to the subcommittees to decide?
I mean, again, I don't mind if there's different practice areas. So if that means we're gonna ask the subcommittees to address this first, that's fine. But I think it needs to end up in a regulation in the rules of court. And I don't think that's what the practice area subcommittees are currently contemplating. They're looking more at tasks that should be included or excluded. And I think we're the ones tasked with developing the proposed rules of professional conduct and court rules to stand up the program. And I think this is a court rules issue.
I was more talking about, again, I just don't want to repeat myself, but having a default rule of no caps and send it to the subcommittees. I want to trust those people in each subcommittee to decide whether fee caps in their area of specialty is even realistic, needed, and what it's going to look like. I don't think we should decide it here because I have questions.
So I agree for what the fee cap should be, or if a fee cap is possible, can be, but I don't think we should have a default rule that says no fee caps. I think that's the wrong, or I would disagree with that default position. I think it should be the other default position, or we could leave it up to the practice groups to investigate if low cost legal services are available in that practice area and what that looks like, and what the if there's going to be regulation of fees, what that should look like. I don't mind if that's practice area specific. But I don't think, for example, for housing, for consumer debt, for collateral criminal, I don't think we should send them the message that the default rule is no caps, because I disagree with that.
So Amos, like, how would you set these caps? So for example, because all we're hearing from the practitioners is how complex all of these cases, like the consistent message from all of our SMEs in every one of these practice areas pretty much is these cases are incredibly complex. They're very challenging. You might think that they're not, and but they really are. And so like consumer debt, right? How would you set this fee cap? Are you talking about an hourly rate fee, or you're talking about a flat fee?
So it's a really good point. I mean, frankly, my view, and I'd love to hear from the public on this and from the speakers, but frankly, my view on some of the comments about how complex the areas are stems from fundamental disagreement with a paraprofessional program. I think they're arguing that these practice areas shouldn't be included, or at least substantial tasks in the practice area shouldn't be included in the paraprofessional program. I think it's a different question than if they're going to be included, should there be any regulation of fees? And I think that investigation that we need to do is a little bit different, which is what is the available service? What is the cost of available services to hire an attorney to do this? And to see if we can create some reasonable regulation that would ensure that what we are proposing is in fact a lower cost alternative, or at least not double or triple or quadruple the price of what hiring an attorney would look like.
And how would you propose to find out what the rates are that attorneys are charging?
Well, and this is Justice Patrick, also keeping in mind the geographic differences around that, right? Because that's part of my concern here, quite honestly, is I think that what a consumer debt person is charging in, Tulare County versus LA County could be very, very different.
Even availability of attorneys. So it might be very different.
But I think I don't know that there's any reliable way to determine what attorneys are charging.
Because they're not required to disclose, right?
Right.
They don't have to report it.
And then we're charging the paraprofessionals with doing something that is impossible to do, not charge above an attorney in their area.
And they will.
So why don't we
regulation on vagueness grounds?
Yeah.
Why? Yeah, again, my preference is not to be vague at all, to be very, very clear. But
be very clear. I'm sorry, very clear in what sense? Like set a dollar amount?
Yeah, we could set a dollar amount, and it could be by county, it could be by jurisdiction. We could follow what the courts have done.
That's where the questions comes from, is how do you determine that dollar amount practically?
Right. So we are the regulator. It's not a comfortable hat for us to wear because we're lawyers and judges otherwise, but in this area, we are the regulator. And that's our job. If we're going to create regulation, is to investigate and propose. That's not usually what attorneys do. That's not usually what the state bar does. That's not what judges do. But we are proposing to license and regulate a new professional. And so that is our task. There's not going to be a 100% answer.
Yeah, no, of course not. But I do think it's part of our lively discussion is what is the appropriate form of regulation, right? And whether there should be fee caps at all, and if so, in what area? I mean, we'll have the discussion with the larger group, but I think there's a lot to be said on the other side of it concerning the market and other ways to do protection, such as making it, as we've been discussing, painfully clear that when someone is retained, when a paraprofessional is retained, the kind of disclosures that person needs to make it painfully clear that they are not attorneys and all the things that they can't do and what is available by legal aid. And so I completely appreciate the consumer protection aspect of it, but I also have a little bit of concern in that I do think that, consumers are not just going to blindly go to paraprofessionals and pay just as much for what they could get an attorney for or even more. So anyway, I hear you, we need to regulate this, but I think it's still very much an open question what that's going to look like.
I definitely appreciate that. And I agree with some of the arguments on the other side. It's not an easy question. And I don't have confidence that we're going to end up with fee caps. I think the wind is blowing in the other direction. But I think what you're saying about disclosures might be a good compromise. So at least what I have in mind for informed consent, informed consent is disclosing the risk and alternatives. And so there may be something we can do in informed consent that may be a little bit more specific about disclosing, what other services are available. If you're going to hire an attorney, this is about how much it costs and mine is higher or lower. Again, I don't know that we have agreement on that kind of detailed disclosure, but disclosures and informed consent is another possible way to handle this.
And I'm kind of concerned about the investigation part of it and who's going to do that. So for example, this one provision you just talked about that, an attorney in this area charges this much and I charge this much. How is the paraprofessional going to find that out? Because attorneys are not supposed to disclose. I just want us to stay away from arbitrariness in kind of coming out with these regulations and really not be unfair to the paraprofessionals. And also, we're always assuming that the client, I've seen a lot of abuses, both with attorneys and paraprofessionals, but we're approaching this fee issue, I feel like that every paraprofessional is out there to get the client, and the clients are too dumb to realize it. And there may be some pattern there, but I just think that's why I think the market would rule it that client knows they're not hiring an attorney, that the attorneys are more expensive. And if their hourly rate charged too expensive, they're not going to, if they're there for a lower cost service, they're going to know what's too expensive just because they know. So I just don't want to regulate this too much.
I don't know if you all, I don't remember which meeting she spoke at, but it was one of the paralegals who speaks at our meetings, and she made comment and sort of said that she was getting offended by some of the messaging, because she was feeling like there was this message that we're all like, if we're not lawyers, we're going to be incompetent, corrupt, and take advantage of people. And I think we also I do have this concern that there's this idea that people that can't afford to hire a lawyer or choose not to need to be protected. It is a somewhat paternalistic view. And, as I've said many times, I have a very good income, but for a serious issue, I would have a lot of trouble affording a lawyer. They're really expensive. So, and I don't think I need to be protected. So I do feel like we need to, I just appreciate you keep raising that for Eva. But I think maybe Justice Petru and I will need to talk about a way to advance it, because I do think it's very philosophical at its heart. Linda and I are fortunate to have worked together many years ago and developed a regional rate structure for court-appointed dependency counsel, 100% paid for by the state. And I think if we were going to try to go in that direction, we do have a methodological framework that we could draw upon to have like 5 regional rates, and how you would try to begin to get source data to peg the paraprofessional rate to. We have something to start from, but I think at its heart, it is a philosophical debate, and we have to figure out how to advance it, maybe with the full working group.
Except that I would like to point out that what we pegged it to was publicly available salary information. And that is the big difference between, you know, that effort and the idea of pegging it to privately hired attorneys, where information about their what they charge is not generally available. So I think that's a very big difference from what we did with court-appointed counsel.
Yeah, I want to recommend, I'm sorry, let me just finish with this. I want to recommend that we send the question at least to the subcommittees, not the decision, just the question. Agree or disagree. If there was going to be some sort of a fee structure or a fee cap, what would it look like for your subcommittee? Not a decision, just kind of pull them and kind of ask them to come up with some sort of a structure.
So let me talk to Lee about this. My concern is that we then wind up having the same conversation 6 different times, as opposed to having the conversation as a full group. I mean, there might be some specific differences, such as areas where there tends to be a flat rate structure. And by the way, what's stopping a paraprofessional from offering services on a flat rate as well? I don't think we're going to mandate that paraprofessionals have to charge an hourly rate. But, you know, I do think, as Lee was indicating, there's some basic philosophical underpinnings to the discussion. So my concern about sending it to the subgroups is that we have the same conversation too many times.
So I agree with that.
One meeting just about that, just like we're having one meeting about in-court representation.
So what I would like to see, if it's possible, is for us to try. So we do have this philosophical discussion and disagreement about whether there should be fees, and I think that needs to go to the full working group. But I think it should go with alternatives and practical recommendations for, if we were to try to regulate fees, would it be legal, and what would it look like? And if there's more than one possible approach, you know, what the 2 approaches would look like. And I don't think we should just have a philosophical discussion without that framing, because then I think we've already had that and we know there's disagreement. I think to move forward, we need to say, for the people who don't think any regulation is needed, fine. But for the people who want to consider what a regulation would look like and potentially consider if it's something they would vote for, you know, what would that look like, and what are the alternatives? And I think that's for us.
Yeah.
So perhaps, because it's 3, but what Linda and I could do is give you like a very brief overview of what we did for court-appointed counsel, because that is one model. And you set regional rates and the data inputs, and I'm flagging all the difficulties as Linda raised. There are court fee schedules for court appointments. I think that's slightly different though, because attorneys can or cannot choose to take those cases, and they have other cases on the side. We're talking about regulating the entirety of someone's practice, right? So, but we could pull together some fee schedules and take a look at that. And here, kind of go through it with you here about different possible options for developing fee caps if you wanted to. Given that it's 3 though, Greg, it sounds like we are going to keep the concept of the unconscionable fee rule. It's not going to change. We're just talking about, will there be an additional overlay of a fee schedule?
Right, and I would just say, moving to flat fees, really what you've proposed, Amos, really tracks what we have for attorneys. I had some suggestions about what could go in comments and what should stay in the rule and what has its counterpart. And then the last big, that last big fish we've got to deal with to fry is contingency fees. And the extent to which we want to, at least on a broad level, allow contingency fees or allow it in certain circumstances and not in others. Certainly in family law, we don't allow it for attorneys unless they're enforcing a family law judgment.
Okay. And Greg, maybe you and I can meet separately because I just want to see where we are overall vis-a-vis the April meeting.
Yes.
Yeah. Okay. All right. Thank you guys.
Thank you. Bye-bye.
Bye.
All right. Bye-bye.